right. Well, welcome everyone to TOKY Office Hours. This is our April 2026 edition, and we are super excited to have Sharon Toerek with us. Sharon's been a guest on the Intangible Brand podcast, so you could consider this to be our Law and Order crossover episode. Um, and first time, Sharon, that we've had somebody from the podcast also on Office Hours. So
Oh, wow, I feel
appreciate.
special. That's
I
awesome.
I appreciate you joining us for this. Um,
I'm glad to be
so,
here.
yeah, I think there was a lot of stuff that we didn't get to talk about as much in the Intangible Brand podcast, which I would encourage people to go and listen to because we talked about um, brand and sort of the impact of having control of and ownership of your brand from a legal perspective and the value of brand. But this venue with office hours is a little bit more nitty gritty, gets into some of the um, details of things. And I thought, given some of the work that Toki does around naming and the challenges that come with naming and trademarks and things like that, that it would be fun to have a little conversation about what what goes on behind the scenes. It's something that you do every day. It's something that we do very frequently, but it's not necessarily something that our audience does maybe more than once in a career. So there's a little bit of mystery behind the trademark process and the people who are approving trademarks and all the rest of that. So maybe we could talk a little bit about that. I've got a few questions lined up, but please feel free to jump in with specific thoughts that you might have. But I think
Got it.
just to get started, maybe tell us a little bit about you and your firm and the work that you do, who you work with, and the work that you do.
Right. Well, first of all, thanks for having me back. I'm honored to be the your first crossover test case here.
Absolutely.
Um, so I'm the founder and the CEO of a law firm called Torek Law. We do business in our client vertical, which is marketing services agencies, as legal and creative, and we basically help marketers in one of three areas, and IP is a huge leg of the stool. Contract development and negotiation, which a lot of times is how you leverage IP, is the
Right.
second leg of the stool, and then quite a bit of marketing regulation compliance, including proper use of brands and branding and other IP in marketing communications. So I've been a trademark lawyer for over 25 years and eventually found my way to serving marketers generally and marketing services firms more specifically.
That's awesome. So when a firm is going through the process of needing to rename or come up with a new name, what are you typically seeing as the trigger for that? Is this often something that's more proactive? Are they reacting to a problem? What drives an organization to go through a renaming process?
Right. Well, not always market factors, but sometimes it's market factors. Maybe it's a brand that is a legacy brand but has become less culturally relevant,
Hmm.
right? In today's marketing world. Maybe it is a brand that needs to change or evolve because the ownership structure of the company has changed or evolved,
Yeah.
or multiple brands are now going to be housed together in one big organization, and so they need to be thinking through their brand strategy. Sometimes just a flat out new product
Hmm.
release. Sometimes trademarks and brands exist in the slogans and the taglines that become, legendary or ubiquitous and associate themselves with the brand. And so it sort of depends on where the company is from a marketing and sales perspective, what their corporate strategy is overall, and whether or not they're bringing anything new, fresh, innovative to the
Yeah.
marketplace.
So, um, because this is a bit of an opaque process sometimes, and I think for our listeners, they may be wondering, what does it take to gain a trademark on a name. Could you maybe talk at a high level? What is the process that you typically see when you're working with your clients to who are often have their own clients, right? So you're working with firms like Toki, who in turn are working with our own clients. So our clients are the ones usually going through a rebrand or needing a name for a new product, new organization, or something of that nature. What does that process at a high level look like?
It all starts with clearance, and that really means doing a significant deep dive into not only other trademarks that are registered and out there, but also other what we call common law uses of brands in the marketplace, social media channels, website URLs, all the search engines. It's looking in all the places, including those that reflect other registrations and those that just reflect other brand uses to make sure that you don't move forward with a brand idea that you've fallen in love with, but that won't stand a test of time. And so we start with a trademark, what we call due diligence. Um, and then, assuming you get clear results through that process, you begin the application process with the federal government. And a lot of this, I mean, I'm speaking very generally,
Sure.
obviously, but a lot of this is going to depend upon what is your, market for the
Hmm.
product or service you're gonna be branding with this name or
Right.
this series of words, if you will, or logos, whatever it might be. So trademarks are category specific, and so the protection and the way they get examined by the trademark office for registration is category specific. So we developed a strategy for applying for the trademark, submit the trademark, and then, Jerry, we all sit around and wait for about 9 months while the federal government, takes a first look at the application and lets us know whether it's gonna pass scrutiny right away, whether they've got some additional questions for us about it, or whether they're gonna refuse our registration on some legal grounds that we'll have to react to. So those are kind of the first 3 steps in the process, and it just drives home why searching and clearance are so important because there's going to be a big quiet period. And as a marketer, as a brand marketer, you're not going to want to wait those 9, 10 months, whatever it is, to adopt your brand because you're waiting on what the government might say about your application. And so the clearance and trademark research is so important
Hmm.
before you go to market, and then you wanna get your application submitted as soon as possible so that you're in the queue as quickly as possible because the volume has increased just exponentially since I've started my career, and we've never seen it as long as it is now, and they're trying at the trademark office to reduce wait times and things by introducing new technologies, and I'm sure AI will create some solutions for maybe streamlining some processes, but it hasn't happened yet, and I don't
Right.
see it changing materially for the next couple of years at least.
Yeah, well, so thank you for that because I think that you are hitting on a couple of key points that that marketers need to be thinking about. The first is how long it takes to actually get a trademark or even the first opinion from the trademark office on whether or
Mhm.
not you're going to be able to gain that trademark. And you're 100% right. When clients come to us, they're not coming to us saying, "We'd love to have a new name and trademark in 24 months." They're usually coming to us saying, "How fast can we get it done?"
Yep,
So, that 9-month period, certainly in a best case scenario, you would sit back and you would wait and you wouldn't do anything with that new name that you've put so much time and attention in. But the reality for our marketing clients is the name's just almost the starting point for all the other work that they're going to do, right? We need to do logos. We need to do all the other trade dress that goes around that new trademark, the name, the look and feel. We want to be out in the market with that, building a website. All those things take time. And if the name doesn't pass, it doesn't gain registration, then you're back at the starting line, right? Starting
right.
over that same process. So you talked about the clearance process, and I think that's a place that's worth, digging in a little bit deeper because the US has uh, some case law and some a little bit of ambiguity has been my experience in exactly what will or will not pass. But I think one of the key differences is the you mentioned common law. So this idea that it's not just about whether or not you have an officially registered trademark with the U.S. Patent and Trademark Office, but it's also the usage of that name and whether or not there is senior precedent with other organizations using that name, even if they haven't, gotten a trademark for it. So, could you maybe take a step back and this is sort of a two-part question.
Okay.
One is, what are you looking at when you're doing this search? And second, um, what is the kind of what are the things related to usage and common law and sort of territorial scope of, and the category, right? You mentioned categories, and that can sometimes be um maybe a little vague. I mean, it's been my experience looking at the categories that sometimes it's like, I don't know if this business fits in this category or actually, maybe it actually fits in multiple categories. We're talking a lot of our listeners are in architecture practices or engineering
Mhm.
practices. So they may actually fall in two or three different categories depending on exactly how they're practicing.
Right. Yeah, we see this frequently, and I'm gonna walk through everything you just asked, and but before I do that, I wanted to just add a comment to what you said earlier regarding timelines. And I think brand marketers who are engaging with a brand development firm like Toki, what they also need to understand is you all need your time to do your brand strategy development, right? I
Right.
mean, it's not just as simple as, hey, we need something new. Someone in the shoes of an organization like Toki is going to need time to ask the questions like, why? Why are we changing the brand? What are we trying to say with the new brand? There's a lot of
Yeah.
strategy, and you've got to build the time in for that to happen before you settle on the next parts of the process, which we're going to walk through.
Right.
So, in terms of where we look and how we determine the viability of a potential brand from a trademark perspective, we're looking I always say you start with the number 1 and 2 reasons why a trademark application is most likely to be refused by the
Okay.
trademark office, because those are good warning signs for everybody to be thinking about from the beginning so that, you avoid some missteps. And what are those 2 reasons? The first is the mark is too descriptive to really serve as a source identifier. In other words, it's a phrase that might be too generic, and it's like using the term grocery store to describe retail grocery chains. It's
Mhm.
now there are examples of, marks that are quite descriptive that have achieved trademark protection, and I can talk about those as exceptions to the rules. But in general, number 1 and 2 reasons is it's too descriptive to serve as a trademark. The number 2 reason, is it's too likely to cause confusion with some other registered mark in similar categories of goods and services. And we've seen a market uptick in this argument being asserted by the trademark office in the last 5 to 7 years. And so applications that frankly would have been approved, 7 or 10 years ago,
Mhm.
have much less likelihood of getting approved on the first round today. And first of all, there's just so much more traffic out there. There are so many
Right.
more brands seeking protection. And second of all, I just think the examination criteria has been tightened up, and they're not always right, but that doesn't mean it's not going to cost you time and legal argument to get it sorted out, right?
Right.
So, if you keep those 2 things in mind when you're working to select a brand and determine whether you think it might have a viable pathway to being legally protected, you wanna look at, are there other competitors using similar phrases, slogans, brands, who we might be confused with?
Mhm.
Maybe, we're a national brand, but maybe we're primarily sticking to a certain part of the country. But there's another regional brand that also is technically national in a different part of the country. And might we clash with each other, or might we not be able to both get trademarks? Because you won't. Only one of you is going to be successful. So you want to look at likelihood of confusion with potential competitors and also potential providers of goods and services and categories that could blur into yours. And a good example of this is brick and mortar retail versus online retail,
Mhm.
or consulting services with marketing and advertising services. These are just things where marks might exist in both categories, and it increases the chance that you might not get your registration very easily.
Right.
So you work backwards that way, and then you start your search, and I can happily walk through what we're looking at when we do a clearance search, so that category by category, at least the major ones, so we can understand what's sort of important to be, what corners to be looking into, right?
Yeah.
If
Oh,
it
before we do that, I wanna tap on a little bit more the 2 things that you're looking at. The first is this idea of being too descriptive. Um,
Right,
I think that's one of the challenges that we see sometimes in the naming process is there's a desire to have the name say what you do. Um, with the idea that, people don't know who we are and they don't know
right,
what we do. And if the name can communicate that more effectively, then it's going to be better from a marketing perspective.
right,
Um, but the second point that you made is the confusion, and that seems to be the thing that is the biggest driver for the patent and trademark office in terms of how they are doing their evaluations. Their job is to protect consumer interest, um,
right,
and um, so both of those criteria that you're thinking about are about protecting consumer interest. One is you don't want to take the generic term for something and lock it up in a trademark, which makes it very difficult for competition to talk about a product. And then the second is you don't want to create confusion in the minds of the consumer between two different products, two different services, two different companies. So
right,
those are sort of the motivating factors behind, I think, what the trademark office is doing. But it hits on some things that I think sometimes create some additional confusion, particularly on the does it cause confusion. I remember back at the early 2000s when there was a lot of dot coms and we started to see novel spellings of things, right? I think Flickr without the E is a great example of that. And so I think sometimes marketers think, well, if I just come up with a more novel way to spell something, then that can avoid that confusion. But that's not always the case. There's other criteria that come into confusion. Can you talk about things like sounding alike or looking alike that
yeah.
they're going to take into consideration?
Yeah. Well, I'm chuckling to myself a little bit as you mentioned. I I wish I had, a dollar or maybe 5 for every time we got asked at the firm, "What if we just change the spelling?" Or, "What if I just change a letter?" Or, "What if we just make it plural?" Or, the idea is not so much to see what you can, maybe get away with in that regard, but is it really likely to change a consumer's perception of the
Right.
brand in terms of, and you're 100% right. What the trademarks system is set up to do is designate who sells what. And so, as a buyer, you will know what the source of the origin is of the thing or the service that you're buying. And so, um, changing a brand that is in use by someone who is in a category that is either identical or close to or adjacent to yours is a bad branding and trademark decision. I mean, I'm not gonna say it's a bad branding decision because there's lots of branding and marketing reasons for being overly descriptive
Hmm.
or, in your marketing, and I'm not a marketer, I'm a marketing lawyer, and so I don't make those decisions. But what I can tell you is that making those small little stylistic or grammatical or spelling adjustments isn't going to allow 2 trademarks to live simultaneously in harmony without causing some likelihood of confusion. And So if the trademark office has wind of that, it's not gonna approve the second one.
Right.
And if the buying public consumes, or is exposed to both of those, that's a risk that I wouldn't recommend a marketer knowingly take, when there's other opportunities for branding that are more unique and stand out and, um, protectable.
Right. So thank you for the clarifications. Let's go back to the process a little bit on what you're looking for when you're doing that clearance search.
Right. Well, obviously, we're starting with federal registrations, and we also want to, even though at this point in the game they're a little bit quaint almost, but we're looking at state registrations because they can give us clues to other common law users who
Hmm.
might be using a brand but not have gone through the federal registration process. So we're looking at state registrations, and we're looking at social media usage. We're looking at YouTube as an incredibly valuable search engine for, terms and marks and things. And so we're looking at social media channels. We are looking at common law business directories in the industry that, may give us some clues to other users.
Hmm.
We're looking at industry trade publications and other common law sources to see what sort of unregistered use. No, we're never gonna get 100% of it, but the
Right.
tools out there are so much more powerful now than they were even a few years ago that we're sweeping, and then we're looking at domain name registrations, and the one reason I wanna call this one out is that a lot of marketers fixate on getting that perfect URL
Mm. Yep.
for the campaign or the product or a microsite or even the company's new site. And it's great if it's available, and obviously, if you find it, buy it right away because it won't be there the next time you go and check on it. However, it's not trademark clearance.
Hmm.
You could have 2 companies in completely different categories of product or service, um, use almost the same URL, and it's not trademark infringement.
Hmm.
They're simply using a mark in different industries and not in conflict from a trademark point of view. So, and the challenge with that is that the marketer will stop there and say, "Oh, it's clear, it's available. Let's
Hmm.
go." Okay, it's available as a domain name. Again, buy it. Secondly, not gonna eliminate the need to do your trademark due diligence because
Right.
trademark availability and domain name availability or social media channel naming availability are not all the same thing,
Right.
and what we're shooting for is a brand that can be ubiquitous everywhere, but it's got to start with trademark foundation.
Right. And I would add to that that securing a URL that is just the name of the company these days is it's very, very challenging, very difficult. So I think
Yeah,
marketers should be understanding of the fact that they may need to be creative in the search for a domain, even when they have legal clearance to use the name in their category, as a trademark.
right.
Um, I want to pause for just a second and see if there's any questions from anyone that's on the call before we move on, because I have lots of other questions to get to, but I want to make sure
Yeah.
that folks have a chance to ask questions.
Hey. Yeah, I've got a question. Hey Sharon.
Hey,
It's
Laura.
been really fascinating discussion so far. Thanks for doing this. My question is really about the like client experience part of this process. Jerry, you mentioned at the outset how, so many times folks are only doing this maybe once in their career.
Right.
And I it's like a you don't know what you don't know sort of experience. So how do you recommend setting expectations, in such a way that you're not gonna freak people out about this process that they're about to go through? Because it can take months, as you're saying, sometimes a year or more. A lot of times it can even, any kinds of like organizational, cracks or like political kinds of tensions that are already there are gonna come out in this process, and it's going to show.
Yeah.
Because this it's something, it just kind of gets to the heart of an organization's identity in a way that even a logo redesign doesn't quite cut to.
Mhm.
So yeah, how do you set people up, for success here? How do you set expectations without scaring them away from the process?
Yeah. Well, I have some thoughts, but Jerry, I'm sure you've got some perspective on this from a brand development
Sure.
point of view. So I will let you take this one first, and then I'm happy to share a couple of my thoughts on that.
Yeah, I think some of it, and this is the part that I'd love for you to comment on in addition to the thoughts that you have, which is it's partially about risk management. The and it's about education. So I think from my perspective, if you're a marketer who's about to shepherd an organization through this process, it's really important to set expectations up front in terms of what is the process, what are the kinds of things that will derail that process, and helping everyone who's involved to understand that you know compromises will need to be made along the way, that there are no perfect answers, that our role together, us as well as the attorneys that are involved, is to develop the best options from a brand strategy perspective and protect as much as possible the risk for the organization. I mean, the risk, and correct me if you feel differently, but to me, the risk kind of falls into two categories. One is the more existential risk of being sued at some point because you are infringing on somebody's trademark, um, and then the more immediate risk of making the investment into this process, developing the brand, developing all of the assets and collateral that go with that, and then at the end of that process, not succeeding in gaining the registration and having to go back to the starting line. And so I think from my perspective, the one of the most critical things is that the board or the C-suite or whoever it is that's going to be approving and making the final decisions on behalf of the client needs to understand that what they're doing is balancing that risk. The risk of what we can definite what and I definite there is no definite, right? But
Right.
be what we can be more assertive in saying we believe that this is going to gain or it has a very a highly like it's higher likelihood of gaining a trademark at the end of this process versus something that has more roadblocks, and listening carefully to the advice that you give as you're pointing out what are those potential roadblocks, and what are the ramifications of what might transpire during that process, what's the likelihood of different outcomes from that. So setting those expectations to me is the single most important thing, and to some extent setting them low, particularly if you're in a competitive space. And there's just a lot of things as you've kind of enumerated that you have to take into consideration, and it's not as straightforward as it is in some countries where the trademark registration is the end all be all. In the U.S., we're a lot looser about that, right? We are here to protect all businesses. And I want to talk a little bit about expansion, national expansion that a lot of our clients are going through, but that can create some of those situations where you have to be making decisions about your trademark.
Right. I 100% agree that this is a communications challenge in the inception. I think that it's about making sure that all the decision makers and the stakeholders are fully informed, not only about risk, but just about what the process itself is like.
Right.
And then I would add to that, I think, in addition to communication, and as you put it so well, Jerry, education, collaboration needs to
Mm,
really be a part
right.
of the recipe for success up front. Because if, from our position at my firm representing the brand development firms, not necessarily the brand holders, the ultimate brand holders, um, there's a management of expectations, right, all 3 ways, right, between us and the agencies who engage us. I mean, and sometimes the agencies will have us work directly with their brand clients, but in either case, internally at the brand, there's likely to be opinion holders, and they might
Mhm.
be legal department opinion holders, they might
Sure.
be compliance opinion holders, they might be CMO opinion holders. You've got to make certain that, there's a collaboration and that everybody it's almost like there needs to be a mental dashboard, if not an actual digital dashboard, between everybody working on it so that we can understand, what the findings are, what the risks are. And over time, as we've seen so much nuance in this area, we've really evolved to it's gonna seem so simplistic, but really a red, yellow, green light
Mhm.
framework for helping clients who are gonna be future brand holders understand that there's never zero risk, as you
Right.
pointed out, or almost never zero risk, but, um, the risk from there on, once you accept that as fact, go from red light, which is pretty much, "I'd like to lay in front of traffic to stop you from doing this," to
Mhm.
green light, which is, "We're not seeing any reason why you shouldn't proceed."
Right.
And so proceed now, not 9, 12, or 15 months from now,
Right.
because, the 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 the
Order
landscape is
matters.
clean today,
Mhm.
and you want to get your number at the deli counter in line because that
Right.
is the way intent to use trademark practice works. It's getting a place in line for your registration and then go forward and, prosper with your adoption plans for the brand.
Yeah. So some of our clients, and Laura, I apologize. Did you have a follow-up to that, or that answer the question?
No, that
Good.
was good. It's always a little bit of a balance,
Right.
in how to accurately gauge or set, expectations for folks and keep them enthusiastic and engaged and, making sure that they are engaging all of the right stakeholders internally at the right times.
Right.
So, yeah,
It's a
that's
great
Well,
helpful.
question, and every organization has a different level of appetite for risk, and so
Mhm.
you have to take that into account also.
I think too, people really, kind of underestimate the emotional component to this
yes.
process
Mhm.
too.
So true.
Man, like you were saying, Sharon, a second ago, like there can be some pretty, opinionated voices in the room, and it's like, it just kind of all comes out and you don't sometimes they surprise even each other,
Yeah.
at that level, so
And I never wanna be that in-house marketer or that agency who has gotten the brand holder in love with an idea for a
yeah,
brand or a brand concept and started down the path, to Jerry's point earlier, of investing in how that's gonna be expressed in packaging, corporate identity, brand standards, whatever, and then it's without vetting it, and then having to have that hard conversation, "Well,
Right.
yeah,
guess what? We just burned through 6 figures getting ready, and we didn't do the due diligence, and it turns out the results are not so good for us." And so either you have to make some hard decisions and have some hard conversations, and we never wanna see our clients in that position, and so, early and often is sort of my motto when it comes to the due diligence part of the process.
No, that's so good. That was actually one of the questions I was gonna, pose. What in the spirit of already knowing the answer to the question, but early and often for sure, you wanna go through, and it's why as a agency that's helping to develop the brand name options, we're doing an early version of what you do a deeper version of, because there's a lot of things that we can eliminate right off the bat that
Right,
would fall into that red category or the deep, deep yellow category. So what we're trying to bring to you, um, in our process is things that we think are green, and
mhm,
now we're asking, are they really green? Because our ability to do the kind of due diligence that you do is limited, right? So
mhm,
we're trying to do, we call it a knockout search, but we're trying to do a knockout search early on, bring you the things we think might be green or light yellow if we're really, really passionate about the idea, in the
Yeah.
hopes that maybe what we thought might be a challenge, you don't think is as great a challenge because you understand the nuances of the categories and things like that, so that we can get down to a smaller list to present to the client. But one of the things we always tell them is before it goes through that deep diligence where you give it that red light, green light opinion, they should not fall in love. They should really try to have 3 to 5 or more options on the
Right.
table that you're able to do that due diligence around, because inevitably some number of them are not gonna pass. Maybe many of them are not going to pass.
Right.
It's funny about the emotion. We sometimes joke, that this is like the naming process for a business is like naming someone else's baby. And if you've gone through the process of naming a child, it is one of the most emotionally fraught things, even between, the 2 parents. But then you start to add in, grandparents and siblings and coworkers and hangers-on who all have an opinion
Right.
about a name. So
Yeah. You
and
can't
f
keep a secret like you do with the baby name, So
well,
lately the parents don't tell anybody until they've
right.
already got the birth certificate dry. You
Sorry,
can't do
can't
that
change
in
it.
a company naming situation.
Yeah, no, exactly. But at
Yeah.
least you don't have to get the baby name registered with the trademark
Right.
office. Can you imagine if that was the case?
Sorry, there's too many Michelles this year, you're gonna have to wait. Yeah.
Right, exactly.
Pick a
There's a
Valerie or
quota.
something.
Um, so a a number of our clients are, growing firms, and they may have established a reputation in a particular state or region or what have you, but they're looking to expand their footprint, and either through acquisition or opening new offices or what have you, begin to do business in places that they haven't. And in some of those cases, they may not have a trademark on their name. We work with firms that are 40, 50, 60, 100 years old. They were named after the founders. Um, they, enjoy that common law protection, at least within category and geography. But what are the things that we should be thinking about when a firm is looking to expand? If you're expanding into a new territory, what's the potential impact from a trademark perspective?
Well, if you're expanding into a territory where there's another potentially competing user of a brand that's established in that region, what you need to keep in mind is that you're not likely to be able to push their use aside. Um, it can at a very advanced stage become a matter of market power between the 2 companies, and there are some situations where you're able to work out coexistence arrangements and things
Mhm.
like that, but I mean, we've had my favorite example of this is like the Snyder's snack food, right? The
Mm,
Snyder's of Berlin versus the Snyder's of Hanover, where they were both pre-existing regional brands who eventually crisscrossed into each other's territory and who both had well-established common law rights to the brand. And I can't remember whether either of them had a federal trademark, but what they ended up doing was entering into a coexistence arrangement with a lot of package disclaimers about
mhm,
we're not them, they're not us, we're not affiliated with them, they're not affiliated with us. It's not optimal. I mean, it can
right,
happen in some product categories, but so if you're a brand about to grow, if you're a growing brand and you want to expand regionally or territorially, then the choices you may be faced with are either, coexistence, which
mhm,
isn't optimal, but which is an option on the table. Dual branding, where
mhm,
you're brand A in your original market and you adopt another brand in the market you're expanding into, or overall enterprise rebranding, which is painful,
right,
especially when you have a legacy brand that means something, to your
mhm,
point, emotionally to the company stakeholders. And so, um, neither of them are 100% happy solutions, but the common law rights can be very strong,
mhm,
especially with longstanding brands. And you're not going to be able to push those users out and away from their current use by coming in after the fact, just because they haven't federally registered their trademarks.
Right.
And that's not universally true in every country in the world, but common law rights do still mean something in the United States when it comes to the trademark protection for brands. Now, is that a strategy to rely on as a brand holder? Never. I mean, if you we tell every single client that crosses our office's virtual doors that if you have the basis for a federal trademark registration, you should absolutely seek a federal trademark registration. They may tell you no for whatever series of reasons, but there's no good reason in today's business, world to not seek that protection.
Right. Even if you're a small organization that at this point doesn't feel like you're going to grow, you don't know what the future holds. And that protection can afford you the opportunity to make those decisions later on without incurring the pain of having to make a change that you don't want to make.
Right, and also the trademark can become a valuable piece of IP
Asset.
in your IP portfolio as an organization that has economic value in and of itself. So
Right.
whatever you
Yeah.
can do to protect it legally is important to do.
It's an asset that you carry on your balance sheet. It's an asset that becomes very valuable in the late stage of perhaps selling your company or
100%.
valuation of the company for different purposes. So yeah.
Right.
Um, Early in the conversation, we talked a little bit about descriptive names being harder to gain as a trademark or protect. Are there other types of names or things that you would advise someone considering naming to lean into or avoid from the perspective of trying to get a trademark or protect one?
Yeah. Anything that includes reference to a region is something I would stay away from. Anything that includes a proper surname is something that I would stay away from. Only because they range from impossible to very difficult to achieve registrations for it. And some cases you flat out just cannot. So
Hmm.
I'd stay away from those two things. I'd stay away from what I would gravitate towards, and what the trademark law favors are entirely coined or what we call fanciful names. There's a spectrum, what we call kind of a spectrum of protectability, if you will,
Hmm.
for brand names. Fanciful or coined names, names that don't exist in a language that are completely made up. Xerox was a great example of this at one point. Just names that don't have any meaning in and of themselves in the language are great trademarks because they are not descriptive, they're not suggestive, and then you move farther on down the line, arbitrary would be next, and a good example of that might be apple, which is a fruit, but also names a huge computer slash technology company. And then you got suggestive, world's best this
Hmm.
or tastiest that. That's further down the spectrum. And then you get into descriptive and then you get into generic. And the descriptive and generics are things you absolutely want to stay away from.
Yeah, that makes sense. Um, just thinking about, we have just a couple minutes left. Uh, Are there some final thoughts about this process of naming and securing trademarks that you think, um, particularly professional service firms, architecture, engineering, construction firms should be thinking about, or you know, uh, challenges that maybe you've seen them experience?
I think I think professional services firms have already sort of gotten the memo on this, but I think you need to think about brand protection for the enterprise in terms unrelated to the names of any of the founders. I think that's one area of opportunity where you can truly build, you know, brand perception opportunities are more ripe there. And you're far more likely to be able to achieve a trademark registration. So I think that's one thing. I think also I sometimes don't think professional service firms, including marketing agencies, so hello to all of you who might be listening, are take protection of their own brands seriously enough. And um, s- eh, Sherry made the point earlier that it's not about your size, it's about the extent of your potential reach.
Yeah.
And any firm, no matter how small, can have a national or international reach. And that makes distinguishing yourself with a brand all the more important. And that makes the legal foundation for protecting that brand all the more important. So I think thinking along those lines is healthy for a company. And I'm a trademark loving girl from the time I started practicing law, and so I'm gonna always wax poetic about this stuff. But the truth is, in today's reality, including findability
Mhm.
via AEO, SEO, GEO, um, your brand is gonna be crucial to the ability of a potential buyer to find you or for you to be in the recommendation set or the consideration set of someone who wants to buy what you sell.
Yeah.
And so naming is a huge component of this. Branding is a huge component of this. Showing up consistently in all the places, so your brand standards, huge component of this. So it goes beyond, that simple charming circle R. It
Mhm.
really is about not only building an asset that, has financial value, but also being more findable,
Right.
to the people who, you want to purchase your product or your service.
Yeah. No, but well said. Laura, I think I might have seen your hand. Do you have another question?
Yeah, I'm kind of reflecting on some of the, experiences that we've had with this over the years, and it feels like we've run into legal counsel that is pretty conservative in their assessment of a particular name or phrase or what have you, and others that are a little more, I don't know, I guess you could say optimistic or lenient, I guess. What what would you say is a sign that, you ought to get a second opinion on something that,
Mm.
maybe you're not quite satisfied with the advice that you're getting. Maybe it's internal counsel that just doesn't do this every day and they're just not experienced with IP.
Right.
What are some signs or like red flags, that someone should get a second opinion?
I think one possible red flag might be non-reaction to you asking for more creative approaches.
Mm,
I think having the conversation and to be fair, especially to in-house legal, they're balancing a bunch of different things in their portfolio usually,
mhm,
and also their whole reason for being in the company is reducing as much risk as humanly possible, and so the safer answer is always gonna be no. It
Mhm.
just
yeah.
is. Um, and so I think a red flag is just no reaction to a request for innovation or creativity, and what do I mean by that? I mean, if you're not getting 100% green light answers in your first look, um, ask the question, "So under what circumstances might this be a possibility?" And an
Mm,
example answer to something like that might be, "Well, trying to register the name on his own is gonna be a heavy lift. Trying to maybe register the name along with a logo that would distinguish the brand as a whole from these other things we're worried about is a creative or innovative solution that might give us a higher likelihood of a success." So, I think
Mhm.
just asking the question, what creative solutions could help us overcome your concern or this obstacle? And if they're not reacting well to that question, then maybe that's when you get a second look.
yeah.
Yeah.
Thanks.
Yeah.
All right, one fun, maybe fun last question. Is there a misconception about trademark law that you find yourself correcting frequently that you wish everybody knew the answer to?
Uh, yeah, I the most common is the terminology.
Mm,
People thinking that you can copyright the name of a product or service versus trademark. It's vernacular, right? It's
right?
conflating the idea of trademarks, copyrights, and patents, and just understanding sort of the lanes of protection that each provide. Copyright is about protecting the expression in a tangible way of an idea or something. It's not, it's nobody can protect an idea, but it's the expression. Trademark protects names, words, logos, sounds, scents, anything that identifies where a product or service come from. And then patents protect original novel inventions. And so that's the most common misconception, if you will, is just some mixing up of the terminology or sort of interweaving of the concepts
Yeah,
of
that's
IP.
great.
Yeah.
Well, Sharon, thank you so much for visiting with us again. Where can people find you?
Well, thank you for having me, Jerry. It's always a great I always love having these opportunities to talk with you. So, my firm is Torek Law, and you can find us at legalandcreative.com. I host a podcast for marketers called The Innovative Agency. We'd love to have you join us there. And I'm very active on LinkedIn. It's Toerek, Sharon Toerek. So, be happy to chat with you there as well.
Awesome. Well, we appreciate you and the time that you spend with us. We appreciate your invaluable advice, both on matters of trademark and other things that we work with you on, and would highly recommend Sharon and her firm if you are going through a rebrand, whether or not you're working with Toki. Certainly give Sharon a call because her advice is both, I think, conservative in the appropriate ways and creative. So, thank you again, Sharon. Looking
We
forward to the next
appreciate you.
time.
Thanks, Jerry. We had a good time talking with you again.
Awesome. Take care.
Bye.